Hello, everyone. I'm Jennifer Lundquist, professor of sociology and senior associate dean of the College of Social and Behavioral Sciences at the University of Massachusetts. I will be your host for this afternoon's panel, and I welcome all of you here. There are over 230 people registered for this event, which is pretty much unheard of at the end of the school year after graduation, after all the students have gone home. People are tuning in, and I'm so happy to see so many alumni and staff and faculty and students and community members in the audience. So, quick introduction before I bring in the panelists. So for many Americans, this draft decision, as many of you know, was both simultaneously shocking and yet not at all unexpected. And it fits with a regressive turn in our increasingly partisan society, where we often find ourselves in a moment of incredible division about what the nation's commitments to equality and justice should be. So in 1973, the year, incidentally, that I was born, Roe v. Wade essentially decriminalized abortion. And as we all know, the recently leaked Supreme Court draft of the Dobbs case will permit Mississippi to ban abortions after 15 weeks, essentially overturning Roe altogether, and thus allowing about half of our states to revert to, in some cases, century-old criminal laws against abortion and to pass new abortion restrictive laws. As you all know, the issue of abortion and reproductive freedom is one of the most divisive in our society, and it's incredibly complex. Because of that, I will say from the outset that this panel was never intended to be a philosophical discussion, showing all perspectives on abortion and debating where human life begins. And there is a place for that very important discussion, and indeed it's been happening all over our nation for years. Today's discussion comes from a specific angle of perspectives, one that represents over 70% of the American population's opinion that Roe v. Wade should not be overturned, according to the most recent ABC Washington Post poll, and one that generally views this decision as the first step to the end of a universal American right that has been in place for a half century in the United States. So here's the plan. I am now going to ask each of the panelists to give some opening remarks. We received many questions from you all that were sent in advance coming in through the last couple of weeks and through today. Our panelists have incorporated many of these into their opening remarks. And then during the Q&A session that follows, I will pose those that we didn't get to, as well as invite new questions that you can type in as you go, and we will try to get to all that we can. So I'm going to introduce each panelist who's going to give some opening remarks in turn. So let's start first with Jamie Rowan. You could put your camera on, Jamie. Associate Professor of Political Science and Legal Studies, and Director of the Center for Justice, Law, and Societies here at UMass. Jamie, can you start out with specifics on the immediate situation and perhaps a brief overview of the legal history that got us here today?
I have a lot to say about this topic, and I want to make sure that the community understands the court case, the leaked decision, in talking about what got us here. So, to begin by just situating what we're talking about the most common medical procedure in this country. We're talking about a procedure that 60% of its recipients are already mothers, 75% of its recipients are below the federal poverty line. And so this issue affects all people who can birth, all people who can impregnate, but it affects us differently. And we have to keep that in mind about what the impacts of this decision are. So as I go over this decision, I'm trying to basically educate us about what happens when a very potent and challenging social and political and moral issue gets taken up by somebody who has a very clear idea about the right answer should be, and then puts that into a legal argument. So hopefully this makes sense. The leaked decision tells us that Alito, along with 4 other justices, believe that Roe and Casey, which established and affirmed a constitutional right to abortion, should be overturned. It also says that whenever a state makes a restriction on abortion, the court should defer to the state legislature, looking for any rational reason the restriction would be made. In other words, the legislature cannot outright say the restrictions are because we don't believe women should have sex for pleasure or they belong in the home. But anything else, many other things, right, that have no basis in medical care for women could be upheld and probably will be. And I can talk more about Alito's argument on this point, which he reiterated at the very end of his brief, to ensure that the court retains very little power to overturn the coming state restrictions. Now, in deciding to overturn precedent, the decision relied heavily on a standard laid out in a case to assisted suicide, which stated that unenumerated rights must be deeply rooted in our country's history. After stating a standard, judges apply standards to a set of facts. And rather than look at the practice of abortion throughout history, as Roe did, Alito focused on the criminalization of abortion. On that issue, to understand why abortion was criminalized, I urge you to read or listen to Michelle Goodwin, and as well as our co-panelist, Laura Briggs. But to conclude that the right to abortion is not deeply rooted in our nation's history, that it's not part of the Constitution, the decision told a very specific narrative about abortion that was cultivated over decades by an extremely patient group of advocates against choice. And the story basically says the only being in the conversation that has rights worth respecting is the fetus. That, for many of us that read the decision, was the takeaway. The decisions and its effects on mothers was largely absent from this decision. The decision addressed the standards for overturning precedent, including what these were the standards this decision just said. This is what we're going to look at. The nature of the error, the quality of legal reasoning, the workability of the previous rules, their effects on other areas of law, and reliance on the right. Most strikingly, departing from Casey, which says women create their lives in reliance on abortion access, Alito suggested women do not, at least in a concrete sense. And his argument is that no one expressly plans on abortion. And essentially, we can all now modify our lives and our life plans and our relationships when abortion becomes illegal in 24 states. The application to facts in that and previous sections talk about new changes in society, meaning there's new what we call policy arguments. There are changing norms about unwed mothers. We have laws against pregnancy discrimination. And this is something that I'm not sure we should be proud of. There is unpaid family leave for the majority of the workforce, only for a few weeks. And reflecting a line of questioning during the oral arguments that were extremely challenging for any of us that have been pregnant, that the changing policy environment allows women to leave babies at fire stations, no questions asked, with no legal repercussions. So therefore, women don't need abortion access. There's also a footnote about the number of women wanting to adopt, suggesting that poor people who choose abortion, which is frequently for financial reasons, should be forced to carry pregnancies to term and birth, regardless of the risk to their health. So basically, wealthier people who want to adopt can. And again, I urge you to look at Laura Briggs's work on this. Dahlia Lithwick also wrote in Slate about what this implies in terms of slavery. Now, you can tell from my narration that I'm not convinced by these arguments. But I believe that it's important as an educator to make clear why some people, even people who would identify as pro-choice, might be. Now, this decision has come from decades of court cases that have stripped away rights to abortion, with changing standards that the court has tried to figure out, well, if you have a right to abortion, how far can the state go to limit your access? They can limit access to public funds. They can require that a child tell their parent. They can require waiting periods that create a big burden for people who need to take time off. They can impose transvaginal ultrasounds, invasive medical procedures, right? So the courts have basically said the states can do many things. And at this point, we now are opening the floodgates to restrictions outright banning abortions. But what I want to posit in terms of just the decision itself and why some people may agree with this is that there is accuracy in describing the decision-making in Roe as resembling a legislative body more than a judicial body. And there is understandable concern about judges making policies based on their own values, rather than allowing a diverse public to work out its differences in the legislature. After all, I would not want this court interpreting liberty to mean that people can contract outside of certain hour limits, that businesses can pollute, or any other number of contentious political issues that my co-panelists will speak to that are directly implicated from the legal reasoning in this case about what the meaning of liberty is in our abilities to form our personal lives. Now, moving forward from losing choice to gaining justice, I also want to encourage those of us who feel very strongly about abortion access to be willing to listen to contrasting arguments about whether we should be fighting in the courts or in legislative branches and how. And I come to this perspective not only as a participant in the lawyer's brief, in which hundreds of lawyers shared the personal, family, and career benefits of their abortions to influence Justice Kennedy, who said in a decision without any evidence that abortion was not overall good for women, could be damaging. I also come to this as the stepdaughter of an abortion provider whose clinic was bombed and who lost his job in 1972 in Oregon before Roe, as the sister of an abortion provider in San Francisco, a former intake volunteer and board member for the Abortion Rights Fund of Western Mass. So credentials, I believe in abortion access. But when we're talking about abortion, we're talking about sex and what we want for ourselves and our families. And the centrality of those issues to our identities means that it is very easy to harshly blame, defend, and attack people who have different beliefs. So I'm worried that we are going to have the political equivalent of a circular firing squad if we alienate existing or potential allies because they unknowingly use outdated phrases or would be willing to compromise on gestational age limits. I may believe that the state should never be able to force a woman, a non-binary person, or a trans man, or someone with a different gender identity to give birth. But democracy means reconciling diverse viewpoints. And while our goal must be to change our culture, which does not support families, I believe we have to figure out how to build rather than fracture the movement as we play the long game to change policies so that there is actual choice and actual justice for deciding if, when, and how to have a family in this country. I welcome your questions. Thank you for spending the afternoon with us.
Thank you so much for that, Jamie. Great background and really important points on alliance building across diverse viewpoints, something I'm sure we'll come back to in a Q&A. Now I'd like to turn to Paul Collins, professor of legal studies and political science, who is an expert on the US Supreme Court. Paul, if you could turn your camera on, what can you tell us about Supreme Court politics that have led to the current situation? And to what extent do you believe that the leak and the public reaction to it will impact the final opinion?
Thanks very much, Jen, and thanks to the college, to UMass, and to the Center for organizing this panel. I'm really looking forward to our conversation. So in terms of, how we got here, right? This is the culmination of a 50-year strategy by opponents of abortion rights, by conservative Christians, by the Republican Party, and probably most notably by the conservative legal movement. So starting sort of right after Roe, opponents of abortion immediately upped their mobilization following the decision in 1973. And working with conservative Christians, they sought to make abortion rights both a moral issue and a wedge issue that would split the electorate. And to do this, they had to endeavor to make abortion a highly salient issue that could even dictate whether or not somebody supports a particular candidate. And within certain segments of the population, by and large, they were successful. The Republican Party started to recognize the promise of opposing abortion rights as a political strategy and got on board in 1976. And today, it's largely a party whose candidates oppose abortion rights. Obviously, there's some exceptions. But it's important to understand that, while we sort of accepted that that's what the Republican Party looks like today, in 1976, this was not an uncontroversial position. Even within that party, it's important to recognize that Roe was decided by a conservative Supreme Court. It was decided by a conservative Supreme Court by a 7-2 margin, and it was authored by Harry Blackmun, who was appointed by Richard Nixon. But going back to like how we got here, overturning Roe to me is largely about the conservative legal movement, which takes off in the 1980s with the advent and growth of the Federalist Society. And this is a conservative organization that's dedicated to training and networking lawyers, judges, other elected officials. And most notably for why Dobbs is happening now is that President Trump basically outsourced the selection of his Supreme Court nominees and lower court nominees to the Federalist Society and its members. And the group ensured that these nominees would have their conservative bona fides. In other words, they'd be true believers, and that they'd be faithful adherents to the doctrine of originalism. And that's really what this opinion is. Originalism is this, it's sort of a family of judicial theories that calls on judges to render decisions consistent with the so-called original meaning of the Constitution. Now, because that meaning can't change over time, it's a conservative philosophy, and it doesn't allow for a consideration of contemporary values. Now, if we take originalism to the extreme, this means that any non-originalist precedent is not valid, and therefore should not be treated with the respect that we traditionally accord to precedent. That's what's going on in Dobbs. Okay, if you have this extreme version of originalism, you don't give precedential support to precedents that aren't based in the so-called original meaning of the Constitution. I want to touch on two other points. So, this is a draft opinion. The leaked opinion is a draft opinion. And we know that draft opinions change into their final form. So Supreme Court opinions, especially in highly salient cases like Dobbs, they'll go through lots of revisions. And what's really going on here is some bargaining and accommodation between the majority opinion author to other members of the majority coalition, sometimes maybe even justices in the minority. A case like Dobbs could go through, 10 drafts. But, there's been more leaks than just the opinion. And it seems that the majority in Dobbs is holding together. So my sense is that Alito's opinion, it's certainly going to change, but I don't think it's going to change in any major way. I suspect some of the inflammatory language will be removed, but ultimately Roe will be overruled. And that brings me to the third point, which is, how does Dobbs affect other non-enumerated rights? And when we say non-enumerated rights, an enumerated right is a right that's specifically identified or spelled out in the Constitution, like free speech, okay? So in the leaked opinion, Justice Alito states that the decision concerns only abortion rights and not other issues. And in fact, he goes on at some length to explain why this is the case. Despite this language, I have very little reason to believe that the approach used in Dobbs is limited to overruling Roe or is limited to abortion rights. As I see it, the issue is twofold. So first, as Professor Rowan pointed out, Alito's opinion argues that to identify non-enumerated rights, again, those are rights not spelled out in the Constitution, those rights have to be, quote, deeply rooted in the nation's history and traditions. But for the bulk of this country, that meant rights that exist in the minds of white men who were lawmakers. So things like the right to contraception or the right to same-sex marriage, they're not going to qualify under this very conservative standard. Second, the 5-member majority, again, all of whom are associated with the Federalist Society, seem poised to continue to defer to states that want to pass laws restricting non-originalist, non-enumerated rights. And many state legislators have openly discussed doing so, hearing the call from this opinion with respect to certain forms of contraception, with respect to same-sex marriage, and some on the fringe have even mentioned interracial marriage, believe it or not. So what we're seeing is the dismantling of liberty rights that have been recognized for more than 40 years, 50 years, 60 years, depending on the right. And this is all happening under the guise of states' rights and originalism. And I want to be clear that this was never happening in secret. This is the espoused goal of the conservative legal movement, working with the Republican Party and the Christian right. And with a new 6-3 majority, really, it's the 5 ultra-conservative members of the Supreme Court that matter most. We're probably going to see many examples of this type of rollback of constitutional rights that didn't exist in the 1860s moving forward. So thanks very much for the opportunity to share some of my thoughts, and I'm looking forward to the conversation.
Thanks so much, Paul. Next, we have Tanuja Rosario, a doctoral candidate in sociology, who works with women who migrate to New York City in search of reproductive health care services, many of whom come from countries where abortion is illegal or severely restricted. Tanuja, can you tell us about the work that you've been doing in New York City and how this recent draft decision will affect the populations that you work with?
Thank you so much for convening us at such a critical point to have this conversation. And thank you so much, Professor Rowan and Professor Collins, for giving us that background. And as you've both discussed, Roe v. Wade has always been on the chopping block, right? We've had states with abortion bans on the books, trigger bans, states who have continuously demonstrated hostility toward abortion. And one of the things that I wanted to talk about today is really centering reproductive justice. And, even with Roe v. Wade in place, it only exists on paper, for people who are oppressed by these various structural inequalities. And this is where the reproductive justice framework really comes in. We know that people who are going to be mostly impacted by this are BIPOC communities, are immigrants, are queer, are trans, are non-binary folks, are folks living in rural communities. And these are the folks that are already struggling to access care, healthcare, including abortion. And so as Roe v. Wade gives us the right to have an abortion, it doesn't ensure access. And so the reproductive justice framework is defined as the human right to power and resources to maintain bodily autonomy, deciding whether or not to have children, and to parent children in safe and sustainable communities. Reproductive justice is about access, not just choice. So even when abortion or other reproductive healthcare services are available, communities that do not have access to the nearest clinic or do not even have the financial means to obtain these services makes it so much harder. And so the reproductive justice framework really helps us understand and identify those power systems that impact the reproductive healthcare access that we have and how to locate these experiences within the economic and social realities that really shape our lives. So in this moment, a lot of people have been asking me, this has always been happening, right? Our bodies have always been in the line. But it is truly a wake-up call for many of us. It is a moment where, our bodies, our decisions to decide our future is on the line. And it is truly reproductive injustice when our ability to make our own decisions, to family plan, to plan our own future, and to ensure that our communities are really living a healthy reproductive life. And much of my work as a reproductive justice advocate in New York stems from working with Caribbean communities and trying to increase access to care. I am one of the founding members of a reproductive justice organization called South Queens Women's March that really provides education, resources, and advocacy around reproductive health. And so my dissertation really grew out of this work as I realized that, many Caribbeans from Guyana and Trinidad are journeying to Queens, New York for reproductive healthcare services. And much of them are traveling to access abortions. They're journeying for various reasons and experiencing sexism within their households, communities, and doctors' offices. And some are even outright denied from obtaining an abortion, especially this is something I've been seeing in Guyana. There are also several other restrictions, such as bans of abortion in Trinidad, lack of access to clinics in their communities, unaffordable treatment, and the stigma and shame that they also experience in their own communities and families around reproductive health care. So even though these journeys are transnational, it also tells the story of various barriers to access abortion and what it means for the lives of people who need to journey far away to even access abortions. And these journeys are really contoured by various things. They have to find childcare. It can be such an isolating journey if they cannot travel with anyone or know anyone in that location that they're traveling to. And many of the women cannot afford to travel. And so they end up carrying out their pregnancies. And speaking with women that are not able to undertake these journeys, they experience immense stress after their pregnancies. Many of the women who also wanted to obtain an abortion have experienced domestic violence, which have resulted in these pregnancies. And so these are the various realities that shape their lives. And so while there are so many hardships in these realities, I've also found that the grassroots organizing in New York played a critical role in supporting some of these abortion patients and furthering reproductive justice. So critical to their organizing here is outreach, developing campaigns, collaborating with partners, mobilizing the community to get out on the front lines in marches and rallies, to holding educational workshops around the various reproductive healthcare injustices that we've seen. And so these organizations have been really helping these abortion patients, helping them facilitate their journeys by bridging social capital, transforming our very own community spaces here in Queens into really thriving learning hubs in an attempt to increase that social capital and to increase level of trust with healthcare providers as well, and really promoting that collective action within community. One of the interesting things too is that they've really taken importance in the reproductive justice work and understanding how various issues such as gender-based violence and food justice intersect to really increasing access to abortion. And so as an organizer and researcher in this community, I have seen how important it is for abortion patients to work with activists, healers and organizers and healthcare professionals to really foster spaces of activism, storytelling, dialogue, which is really grounded in solidarity and siblinghood, and really engages them to challenge these various inequalities, not just on the local level, but on the transnational level as well. And so when abortion patients know that they have this support network, they're more likely to travel here. And that this is one of my findings from my work. And so given all of this is the support that we need right now for the future of reproductive injustice. One of the questions is how can we organize and engage in this activism as individuals, right? We need to really get educated on this issue. We need to be clear about what we are fighting for and what we are fighting against. We need people to support people who are doing the work, supporting these organizations who are on the ground, who are supporting these providers and these patients. We need to support our abortion funds. We need to support our abortion providers. We need to make sure that these people have the tools and resources that they need to keep doing this work. We also need to ask ourselves, this is a moment where, what can we offer this movement? What position do we hold? Whether you hold power, privilege, or an occupation that can really help us in this fight, do it. Make those connections and add to the movement. We also need to think about, how can we support abortion patients during this time? If we can offer childcare, if we can offer them a ride to the clinic, if we can go to the clinic with them, calling them, checking up on them, and creating that abortion experience that they want and need, and let us show up for them. Let us really center that care and that love in this movement right now. We also need to continue to think about the ways we can really center and amplify the voices and the needs of the lives that are most impacted by abortion and reproductive health restrictions. And it is these stories, right? It's these very stories and dialogues that really help us engage in culture shift to dismantle the stigma and shame that prevent these conversations in the first place. My mom suffered 23 years from reproductive healthcare complications because she wasn't able to speak up because there was no room or space to have these conversations. And so really understanding that, our liberation of a whole is really tied to liberation of reproductive injustice. If you care about things like our right to vote, if you care about economic violence, if you care about food justice, all these issues are linked, and reproductive justice should be important to you. A threat to, reproductive justice is a threat to all of these rights. A threat to accessing abortion is a threat to all of these rights. And we need to continue to have conversations with all of our communities that, abortion is normal. Abortion is healthcare, and it is a human right that we should all have access to. So thank you so much, and I look forward to having a conversation with you all later.
Thank you, Tanuja. And next we have Laura Briggs, Professor of Women, Gender, and Sexuality Studies at UMass Amherst. Last week, she published a compelling op-ed in the Washington Post critiquing the Dobbs draft ruling, and is author of the book, How All Politics Became Reproductive Politics, among other books. Laura, I would love it if you could share with us some of the insights you've written about in your scholarship in the context of the Dobbs draft and all that it entails.
Thank you. So I want to start by echoing Tanuja that the insight of activists for reproductive justice that the restrictions on abortion and restrictions on how people are able to raise children are closely related things. And I'll say more about that in a minute. So US historians have long told a consistent story about abortion rights. And in fact, it was embodied in an amicus brief that was the consensus of the Organization of American Historians and the American Historical Association. So, and that was simply that abortion was legal until quickening. And Alito in the draft says there's some debate about what quickening is. There's very little debate about what quickening is. But it means when the mother or the pregnant person feels the fetus moving in the womb. And that can take place as late as 25 weeks. So at the time the Constitution was drafted, and for more than half a century after that, basically the state of the law was that there were very few restrictions on abortion before quickening. In fact, we know that one of the drafters of the Constitution, James Wilson, who wrote the Constitution's preamble, actually addressed the subject of abortion in a 1790 lecture. And he was quoting William Blackstone, who was the preeminent authority on English common law. And what Wilson said was, in the contemplation of law, life begins when the infant is first able to stir in the womb. So abortion, in Wilson's view, could not be regulated by law before that time. We have many, many state Supreme Courts in the original colonies and the subsequent states echoing that position before the 1820s. The earliest restrictions we see on abortion are in the 1820s. The majority of them are in the 1840s, when we see a guy named H.R. Storer organize a campaign that was largely about pushing midwives out of the practice of birthing and replacing them with medical doctors who are sort of by definition male. And so it was a gendered struggle over a set of medical practices. And the interesting thing, and then the other thing that was happening in the 1850s was we saw a significant fight over abolition. And the key thing to know about slavery, enslavement in the United States, is that after 1808, after the Constitution had been drafted and a set of agreements had taken place between the North and the South, is that importing people from Africa for the purposes of enslaving them became illegal. And so what characterized slavery in the United States was that it had to be reproductive. And that's why we see common practices of sexual violence and forcing women to carry babies to term in order to reproduce enslavement, in order to increase the wealth of enslavers. And that was the other thing that was haunting the debate over abortion in the 1850s, was the question of abolition. Abolitionists were raging in particular against the sexual violence that characterized enslavement and the reproductive practices of enslavement. And so in the 1840s and 1850s, you saw a race-based and sex-based campaign to end abortion rights or the common practice of abortion. And the interesting thing is, historians in the US or historians of the United States have widely agreed on this account since at least the 1960s. This is the history that was characterized in Roe. And what the Alito draft does is to say, actually, that account is wrong. And he's quoting a very small number of essentially Catholic lawyers, in particular, Joseph Della Penna, a law professor at Villanova. He specializes in international law. He has no training in history, but he's been launching an account of the criminalization of abortion. He says that there was the criminalization of abortion in the Middle Ages, in the in the centuries from 1200 to 1500. In Europe, we don't know why this is relevant to the question of abortion in the United States. We don't think that the framers were aware of those cases, if in fact they were what he said they were. There were other cases in which abortion was raised as a question, or stillbirth, but these cases involved assaults on pregnant people that resulted in stillbirth or miscarriage. So what the vast majority of historians think is that we should think of these cases in relationship to assault on the pregnant person, not in relationship to assault on the fetus. It's also very concerning that that Alito is raising this question of the domestic supply of infants. This is a sense that the products of pregnant people's bodies belong to someone else. There is a clear precedent for this in US history, and it's enslavement. This is not a precedent that we want to hold up. And this is why I want to echo Tanuja in thinking about the ways that the contemporary abortion debate, as it's laid out by Alito's draft, as we see it sort of moving into the future, contains elements both of deciding how people who become pregnant, what will happen to their children. You can force people to stay pregnant, seems to be the argument. And I should say that Alito's draft contains only the most familiar arguments from the last 50 years of the anti-abortion movement. There's nothing surprising in there. And I want to compare the kinds of historical debates to the question of, is there climate change? It drives climate scientists crazy, right? They say there are a handful of people who are contesting the climate change question on baseless grounds. That's kind of how historians feel about these people saying that there was criminalization of abortion during the 18th century. There just wasn't. There's an overwhelming consensus on this. All right, and I'll stop there.
Thanks, Laura. And next we have Marissa Pitsiai. She's the Deputy Director of Programs and Policy at Collective Power for Reproductive Justice and co-chair of the Abortion Rights Fund of Western Massachusetts. Marissa, how will this decision impact your work on the ground in reproductive justice activism? And what are your recommendations in addition to Tanuja's for what the average person can do?
Yes, thank you, Jennifer, for having me, and thank you, Jamie, also for inviting me. I'm really happy to be here with you all this afternoon. So as Jennifer said, I am the Deputy Director at Collective Power for Policy and Programs and co-chair of the board. And I really wanted to kind of break this down for you all into a couple.
Marissa, I just want to interrupt quickly and see if maybe you could toggle the connection of your speaker a little bit to see if the sound is a little off.
Sound is a little off.
Yeah.
Is that better if I get closer to the computer?
No, it sounds like it might be a connection issue.
That's
well, carry on. We can still hear you.
and I'll try to talk a little bit louder because I usually am really loud. Let's see. So I thought I would break up the kind of response into the two different organizations that I'm repping today. And start with talking about Collective Power. So really quickly, Collective Power for Reproductive Justice is a leadership development and we're moving a little bit more into an advocacy group organization that is in Western Mass. And we have been around for 40 years, and we have been working to address reproductive justice and reproductive rights, organizing and supporting other leaders and youth leaders and emerging leaders for about 40 years. And so what I wanted to focus on to give people like a little bit of hope, right? Because, you know, it's feeling really hard, it's feeling really gloomy, is that we are doing that work still. We are continuing to build the bench for a sustainable future. That looks like making sure that we are supporting our emerging leaders through building out a historical framework of understanding. So similar to what Paul brought to this conversation, really making sure that emerging leaders are aware of the historical strategies, the historical reasoning behind why the strategies on the right are operating the way they are. I'm muting and unmuting myself. I'll try that again. Did that help? I'm really sorry that it seems hard to hear me. Did that help at all, Jennifer?
No, not really, but continue.
Okay, so sorry about this, and I hope that maybe it's just Western Mass folk are having a hard time. Anyway, so we're working to just really make sure we're bringing in historical practices. We're making sure that people understand that there's a network that they can depend on and that we can really start to form and continue to form the network of support and the network of strategies and ideas that are really critical to emerging leaders and youth leaders that are going to continue to pick up the work and move forward what we will, as all of us leaders in the work, will continue to pass along to them. So I want to speak to that. I want to also speak to the fact around the Abortion Rights Fund of Western Mass and some of the work we're doing. So this is where I think it can be a little bit more exciting and where you all can dive in. So from a local standpoint and a state standpoint, we would like to remind you really quickly that we in the state of Massachusetts already have mass health, right? Like we have already been moving towards liberation in the state for years now. And we have mass health that pays for abortion. So we also just recently passed some key provisions of the Roe Act that made it legal to have an abortion in this state and codified through our state law. Up to 24 weeks, a person can have an abortion, and after 24 weeks, it's between the person and their doctor for fetal anomalies or any kind of threatening to the life of the pregnant person. We also will judicial bypass. So now people in the state 16 and older can get an abortion without any barriers from a perspective of legal barriers. They probably still have some financial barriers, which is what the Abortion Rights Fund comes in, as well as mass health. And we, along with we have three total funds in the state that are regionally based. So there's Emma, the Eastern Mass Abortion Fund. There's Jane Fund, which is in Worcester, so it covers Central Mass. And then there's the Abortion Rights Fund of Western Mass that covers everything from counties west of the central part of the state. We also have a brand new fledgling fund, the fourth fund, Tides for Reproductive Freedom, I believe is their name. I apologize if I got that incorrect. And they're working along with all three other funds to be able to make sure that there's not any kind of access issues around funding and support to get to those, to your appointment. We're also building a regional and as well as state coalition of funds and indie clinics. So from a state coalition perspective of the funds, we are building a coalition across all four funds to make sure that we can create a space where somebody can call us, reach out to us, and they are taken care of and they don't need to be bounced around depending on where they live. If you're from Mass or you're coming to Mass, we want to support you and we don't want you to have a lot of barriers and hoops to jump. So we are in the process of creating a system to address that, as well as looking at it from a regional standpoint. And again, what can we learn from each other? How do we support each other in thinking about what it looks like for people as they're going to be coming to our region, even though we have some really problematic and hard laws that affect our region. For example, New Hampshire has a transvaginal ultrasound rule right now, law that they're trying to turn back. So we are in the process of really organizing to make sure that what laws are on the books in this region are staying in a liberatory way, and then continuing to ensure that our practices are standardized across the region. So again, anybody coming to the state and or region will get the care that they deserve, and they're not going to get different care depending on who they reach out to. Let's see what else. And finally, what I would love to also lift up that's really exciting news is that the House budget and the Senate budget just recently announced that they have put a budget line item of the House budget put a budget line item of $500,000 that is accessible for abortion funds and organizations doing work around abortion access through a grant program with the Department of Public Health. And the Senate version made that budget line $2 million. So we're really excited about the fact that, again, the state is showing up in liberation. The state and this region are going to continue to move towards a place where people can feel safe and be able to receive the reproductive health care that they need. So I wanted to wrap up my final thoughts with how people can get involved, right? So I really appreciate Tanuja speaking to the reproductive justice framework and making sure we all understand that that's where we're operating from. So again, how you can get involved: donate, donate, donate. Donate to the abortion funds, any abortion fund. Literally, there is not a single abortion fund that cannot use your money. Donate to all of us, $5 each. Donate to whichever one fills your heart, feels like you are feeling like you're receiving some purpose in that work. Please consider donating. Also consider donating to the Abortion Care Network. The Abortion Care Network is the organization that supports all of the independent clinics throughout the country. So in addition to donating to Planned Parenthood, it's critical that you donate to the Abortion Care Network because we need to sustain these clinics through this time. We all believe that we will have liberation and we will be able to find our way back towards people being able to access abortions in their communities. But until, and I should say surgical abortions, Carrie Baker is going to do a lovely job of helping us understand some of the various other ways that we can safely move towards abortion work. And we want to make sure that the independent clinics are receiving the funding and the support that they need. Finally, speak up, right? So when we say speak up, right, like Jamie referred to this, like we have to really think about what is our messaging? How are we making sure that we're moving forward a message of power, a message of strength, a message of not fear mongering, right? We don't want to dip into the fear mongering. We don't want to move towards perpetuating language that actually harms the movement. So speak up and make sure you understand what is the current messaging that's out there right now. Planned Parenthood, these larger organizations have wonderful messaging guides on their web pages for you to be able to read and understand. Coat hanger imagery is actually really dangerous and not what we're trying to perpetuate and move forward. So read and go and research to understand why, if that's something that you thought you would like to continue to be able to display and communicate and help people understand. Yes, we don't want to go back, and we don't actually believe that we ever need to. We know that we are in a different place than we were in the 1970s. There are so many other options that, again, Carrie will speak to. So really think about making sure that you're moving forward a message that actually serves the movement and serves liberation. And then also want to talk to those of us that have had abortions, right? For those of us that have had abortions, if you're interested in telling your story, Consider taking a training with We Testify to learn how to tell your abortion story again in a way that's going to move the movement forward, that is not going to create and add to this moral dilemma conversation that happens that allows for some abortions to be seen as morally or more acceptable than others, right? Like when we think about abortion and we think about bodily autonomy, then we also get to hold the reality that it's not for us to be judging any one particular person's decision. So learn how to speak to your abortion, learn how to speak to your story so that it doesn't actually wind up creating and adding to that moral dilemma. And then the final thing that I wanted to lift up is call your senators and reps. Even if you're not in the state of Mass, call your senators and reps. If you are in the state of Mass, there's some really critical bills that are reproductive justice framed and reproductive justice moving us towards reproductive justice liberation, right? So please consider calling your senators and reps. Tell them that you support and you want them to support the act to require public universities to provide medication abortion. I will put some of this link in the chat, or I don't know exactly how we can share resources, but Jennifer, you can maybe explain to us how we can share resources. But we want you to call and support this bill. We want you to call and support the bill around doula services so that people can get the support that they need. Danusia was talking about that people should be able to have the abortions that they need. People should be able to have all versions of the birth outcomes that they want. There are abortion doulas, there are birth doulas, there are postpartum doulas. This bill, there are grief doulas. All of the doulas will be supported through this bill. So consider putting your voice and your words behind supporting that bill. And please understand that doulas actually create really, really healthy birth outcomes for the maternal health disparities that you hear about with Black women, right? Like, again, if we're looking at this from a reproductive justice lens, then we're also looking at folks who are choosing to have children, and we're thinking about and looking at the impacts of medical racism, of all of the things that have come to find that Black women have a 3 to 4 more times likely of dying or having pregnancy complications. And it has nothing to do with our education, right? So really think about what could you put your voice to? What could you help support? We have another one that I would really encourage you to support, 2 more. The Votes Act, making sure that we have voting opportunities that are secure and safe and that everyone has access to voting. And then finally, the last one that I will uplift, but there's so many bills that I can uplift right now. And the last one I will uplift is, now I can't find it. It's for trans kids, and I've lost it on all of my sheets of paper. I will find it and put it in the list, y'all, because it's probably time for me to wrap up my conversation. But please consider doing what you can to support a reproductive justice platform across the legislative agenda. If you're not sure which bills, I'm going to put this link in the chat or share with you however we can share resources, but please consider going to Reproductive Equity Now and reading through their legislative agenda that holds a reproductive justice lens to legislative work. I will wrap up with there and we'd be happy to answer any questions as they come, if y'all can even hear me.
Thank you, Marissa. We could hear you. We just couldn't hear your lovely, usual smooth baritone. It just sounded a little crispy, but maybe you can resolve it before the Q&A starts by unplugging and replugging or something like that. I think Carrie put one of the links that you talked about in the text. And if you have other things that you want to put in, some of the names of the bills and other websites, just put it in the text to everyone, and then the entire audience should get it. And I also am happy to email people resources as a sort of a post hoc follow-up to this seminar. So last but not least, I turn to Carrie Baker, who is a Sylvia Dlugash Bauman professor in the program for the study of women and gender at Smith College. Carrie just recently co-authored a fascinating New York Times piece in which she discussed the role of crisis pregnancy centers, which are anti-abortion clinics, and what role they are likely to play in surveillance and criminal law enforcement in a post-Roe America. Carrie, can you expand on this and describe for us how you are envisioning a post-Roe America based on your scholarship?
Yeah, absolutely. So I did put a link into the medication abortion on college campuses legislation with ways to contact your representatives. I've worked very closely with our local rep, Lindsay Savadosa, on that bill. And it is very connected to what's happening at the national level, because the fact of the matter is Massachusetts will become a destination state, and we need to free up our clinics for people that need procedural abortions and people coming from outside of the state. So we need family family care providers and public university health clinics and anybody that can to begin offering abortion pills to their patients so that they can get the care they need and lift the burden off of clinics so people coming from out of state, including New Hampshire, which just significantly restricted abortion, can get care and without long waiting lines. So, and I also did put in my link to my New York Times piece, which came out last Thursday, and I'll be speaking about that in a minute. But first, I want to dovetail on something that Professor Collins said at the very beginning with regard to what I see as at stake with the Alito opinion. And I do think, I mean, it was a February opinion. I think it will change to some degree, but I think it is a definite sign that Roe will be overturned and probably that it will be this kind of extreme argument of originalism. So just to reiterate, he argues that if a right's not explicitly and specifically stated in the Constitution, and it's not a right that is deeply rooted in the country's history and traditions, the Constitution doesn't protect it. End of argument. That's it. And, you know, as Professor Collins mentioned, that certainly endangers a lot of rights, like the right to privacy, the right to contraception, the right to, same-sex sexual interactions, the Lawrence versus Texas case, potentially same-sex marriage, and other things. But I think it goes way beyond that, actually. I think it calls into question the entire legacy of the Warren Court, which was the court in the 50s and the 60s that basically enacted a lot of the goals of the civil rights movement and the women's movement and later the gay rights movement. And so it would include things like Brown versus Board of Education. It would include things like, as he mentioned, Loving versus Texas, which struck down a anti-miscegenation law. It would endanger the idea that sex discrimination is prohibited by the Equal Protection Clause. And so I think it could be quite sweeping. I don't know that the court will strike all these things down, but it is a blueprint for ending many long-standing rights that we take for granted today. And remember, this is the goal of the right wing. Right? They didn't like the civil rights movement. They didn't like the women's movement. They want to roll these things back. And now they have the blueprint to do it and the court that's perfectly willing to do it. So I think that we need to be clear-eyed. The fact that he was so flippant about, oh, stare decisis doesn't matter. I mean, his arguments for why stare decisis should not apply in the Roe case are very flimsy. And so I really think that all of the rights that we have won through advocacy before the court over the last 50 years are endangered by this decision. Rights that protect not only women, but African Americans, all people of color, and LGBTQ people. I think we need to take that really seriously. And I'm going to be publishing more on that with Ms. Magazine, and I'm interviewing a bunch of constitutional scholars and really trying to explain that argument in more detail. So follow me on Twitter and my articles on Ms. if you want to see that argument explained in greater detail. So the things I want to talk about today, or the 2 points I want to make, I want to say, and this is just my opinion, but I think it's true. Post-Roe is not going to look like pre-Roe. It's going to be grim, but it's not going to look like pre-Roe. And there's two reasons for that: the internet and the abortion pill. Pre-Roe, emergency rooms were packed with bleeding, infected people, women, who had attempted to get abortions illegally and had problems, had infections, had hemorrhaging. Women died. We don't know how many, but women did die. But in greater numbers, they ended up in emergency rooms with infections and hemorrhages. That will happen pre-Roe, absolutely, but not at the same rate. And it's because we have abortion pills. Abortion pills were developed in France in 1980. They were, after a long fight, were finally approved by the FDA in 2000 under a very restrictive regime that abortion rights advocates have been fighting against for the last 20 years. And just last December, the FDA said that docs and all medical providers can mail abortion pills to clinics. and consult with them through the internet, either video conferencing or even telephone calls or online forums. And this is creating a massive shift in abortion healthcare in the United States. And it's happening at the same time and getting a lot less attention than what's happening at the Supreme Court. But I think we need to be paying attention to it, because just as what the Supreme Court is doing, there's a seismic shift happening. A similarly seismic shift is happening in abortion healthcare. Now, as we know, after Roe, 26 states will be certain or likely to ban abortion, at least at some point in pregnancy. But the other states are making abortion more accessible, particularly in early pregnancy, using pills than it's ever been. That's already the case. 20 states, including Massachusetts, you can get abortion pills literally by going on your phone, filling out an online form, or doing a video conference. And you can get these appointments within like 24 hours, and they'll overnight you the pills. You can get them in 24 hours, take them, and the whole thing's over in 3 days. You don't have to make an appointment, wait a week, travel long distances, go back and have another appointment, pay $700. These telemedicine abortion providers, and I did interviews with 13 of them across the country, if you want to get a sense of what that process is actually like, they charge anywhere from $105 to a couple $100. And often they work with abortion funds and or have sliding sale fees. So if you can't spend a dime, you can still get the care you need. And in addition, for people in all those other states, they can contact Aid Access. That's Dr. Rebecca Gompert's service. She's a physician based in Europe, and she serves people in all 50 states. She charges $105 sliding scale fee. Takes a little bit longer to get those pills in the mail, but you can order them in advance and have them in your medicine cabinet. Now, this is, as I said, a seismic shift. However, in states that criminalize abortion, they are going to try to go after people. So far, they haven't been going after people. There's only been about 21 cases that we know of in the last 20 years where people have been prosecuted for using pills. Usually it involves later pregnancy. Pills can be used until through about 12 weeks safely. Actually, you can use them throughout pregnancy, but it's most safe in early pregnancy. And I do want to just say, the pills in early pregnancy, they're very, very safe and very effective, about 98% effective. And they're safer than Tylenol. So, but if you use them early, there have been very few criminal cases involving that. Now, there will be more with what's going on, right? And there are strategies for dealing with that. If you go to my articles, I have an FAQ on abortion pills. You definitely want to use incognito or a VPN so that you don't have a history of searching. And there's other strategies too, that If When How is sharing and other groups are sharing. There's a Repro Legal helpline that gives you information about the legalities of abortion pills and how to use them. And anybody can call. There's also a Repro Legal Defense Fund, which can help you with bail, and I mean, God forbid. And again, it's very rare now. It could be more, particularly in those 25 states post-Roe. And I'll say one more thing, and it has to do with the crisis pregnancy centers. One argument I make in my writing is that these fake abortion clinics run by anti-abortion people, they pretend to be abortion clinics. People get in there, they misrepresent the risks of abortion, they pressure people, they shame them, they stigmatize abortion. These organizations, and there's over 2,500 across the country. I have a map in my New York Times piece talking about how prevalent they are and how much more prevalent they'll be post-Roe. They are the eyes and the ears of the anti-abortion state. They will be informing on people that go to them with pregnancies and needing information. A lot of them are funded by conservative states. A lot of them share information with the broader anti-abortion movement. And I've written on this if you want more details. And they will certainly be informing with SB 8 type laws, but also with criminal laws. And so I think that, and this is like, all the attention's been on the legal advocacy around abortion, and very little attention has been placed on CPCs, but this is basically like the on the ground game of the anti-abortion movement that is going to go into high gear post Roe to enforce these criminal abortion laws. And I think we need to be paying more attention. In my New York Times article, I have some ideas about how to address them. And right here in Western Massachusetts, there are ordinances being already introduced in Amherst and in East Hampton, and potentially soon being introduced in Northampton to address these anti-fake clinics, particularly deceptive advertising. If you go on your phone and search abortion services near me, at the top of the list will be a CPC called Clearway Clinic in Springfield. These ordinances are trying to address some of that false advertising that they do. So there's, again, a lot of ways in getting involved. Please submit your testimony if you've had any experiences with CPCs, or reach out to me. I will connect you to those city councils in those 3 towns. They're looking for testimony, general testimony, but particularly of people who have had bad experiences with these clinics. So I'll stop there. I've probably gone over my time, but I'm open to questions.
Thanks so much, Carrie. So now we are at the point in the panel where we are going to be addressing questions that were sent in previously. I see that a number of registrants have posted questions in the Q&A, and our panelists have been busy answering them, so thank you for that. Before we turn it over to the Q&A, I want to give the panelists an opportunity to ask one another a question or to follow up on something that another panelist had said. And feel free just to break in, you don't need to raise your hand.
Hi, I want to respond a little bit to what Carrie was saying. In one of my other hats when I'm not being a US historian is to be a historian of Latin America. And so this struggle has been very alive in Latin America over the last 5-10 years. And so we can learn a lot from that experience. And certainly the question of medical abortion transformed the experience of criminalized abortion for Latin Americans. However, there is a concern that I have about where the legal end game is for the anti-abortion movement. Because what we see in the brief from the state of Mississippi, what we heard in the back and forth during the oral argument, and in fact, in the lawyer for the state of Mississippi's oral argument itself was, and in Alito's draft, is an argument about fetal rights. And my first reaction when I saw the Alito draft was actually not at all shocked that he was trying to overturn Roe v. Wade, but a relief that he didn't go further. But I think the goal ultimately is to see the fetus as a citizen within the terms of the 14th Amendment. And if that happens, if the Supreme Court goes there, and many people in the forefront of the anti-abortion movement have suggested that is the next move, is something about national legislation embodying fetal citizenship, then medical abortion becomes illegal. And I think we need to be very concerned about that. But I would also hold up that the end game of the abortion rights movement is to either legislatively or state by state to think about opening up access to abortion, medical abortion or otherwise. And here too, I think we can look to the recent years in Latin America that the women's strikes linking violence and abortion rights, femicide, sexual violence, domestic violence, has resulted in, first of all, millions of women in the streets in Mexico, Argentina, Colombia, and Chile, and not incidentally, the decriminalization of abortion in all of those places as well.
I just like to respond to Laura. I mean, yes, their end game is to ban abortion throughout the United States. They've said that, right? If they win 24, both houses of Congress, they are going to do that. But they're not going to stop abortion. I mean, we know if abortion is made illegal, people just get illegal abortions. And the key is that abortion pills make it much safer and much easier to hide. And so, you know, the original abortion pill, misoprostol, was discovered in Brazil in the 90s because on the label of the bottle, it said, don't use if you're pregnant, can cause miscarriage. And the health authorities saw all of a sudden that the illegal abortion death rate dropped precipitously. And there's like, what's going on? And they realized women were taking these pills, and they're still taking these pills. So I don't think that, this is a workaround. This is not a solution. My argument was that this is how we will, not have post-Roe look like pre-Roe. But I do think that we need to spread the word. I want everybody to go on social media, particularly if you know people in those 26 states, and talk about these pills and how to get them. Post Plan C pills. They have a guide, a drop-down menu by state. You can see exactly how to get them in the state. What are reliable websites to order the pills? How do you get to aid access? How can you use mail forwarding to get telemedicine from another state and forward it to your state, even if it bans abortion? So I think that, it's a workaround. It's not ideal, but it's all we've got.
Carrie, I want to follow up with a comment that you had made earlier about, post-Roe not looking quite so grim as pre-Roe, because we have a registrant who poses a question around that, Jenny Folsom, and I'll read to you what her question is, but you can also look at it and read along with me. She writes, isn't it possible that post-Roe will look worse than pre-Roe due to increased opportunities for surveillance and tracking, thinking about changes in technology, as well as a Republican push to criminalize women and pregnant, capable persons for abortions? Furthermore, Republicans are already working to make it unsafe for women to report negative pregnancy outcomes, such as miscarriages. There is also a desire to make it impossible for women to cross state lines to receive abortion care. Missouri, as an example, taking legislative inspiration from the Fugitive Slave Act.
So yes, I mean, the National Association of Criminal Defense Attorneys last November did this amazing study where they talked about pre-Roe, we didn't have mass incarceration. We didn't have this massive criminal justice system. Post-Roe, we do. And I've made arguments in my writing that, criminalizing abortion is going to be like the war on drugs. I mean, it's going to be the war on drugs, which accelerated the criminal justice system so massively. It's going to do that again, directed towards women in particular, and of course, low-income women and women of color. And so what I meant by I'm talking about access to medical care and the safety of the medical care. As far as the criminalization, absolutely, and the surveillance. I do think, though, that, and we need to develop this, there are technologies like VPN and incognito and various ways. We've got to start all using Signal and not, text. We've got to all start using encrypted apps and encrypted technologies for email. And, just even if we're not ordering abortion pills or whatever, if you're organizing around this issue, you should be on Signal, not on your regular text. And I think we need to anticipate that future when these folks are in control of everything, and that we need to still be doing this organizing. So yeah, I mean, I would agree with you with regard to that. And I think that we need to be working on the ground, thinking of those things as well. And by the way, one thing I didn't mention is there's a whole network of support systems in place for people seeking abortion pills outside of the medical system. Self-managed abortion is what it's called, like the M&A hotline, the miscarriage and abortion hotline, or like If When How's Repro Legal hotline. So we're already trying to build this infrastructure to support people post-Roe.
And, a follow-up question that we often hear is, well, at least so far in some of the abortion restrictive legislation that's being passed in various states, the women themselves are never criminalized. Those who are criminalized are, the doctors or those who aid and abet women to get an abortion. What is your response to that in terms of much of the conversation today, which is about, we need to start thinking about how technology is surveilling women as potential felons for having abortions. And that's for any panelist to jump in on.
I have an opinion, but I'm going to let somebody else answer that.
I want to answer it as the person closest to me and that I care most about besides my children being an abortion provider. And so what's happening, I think, for abortion providers who are in states like California where it's legal has been planning for quite a while now to travel to the border states and set up camp and support the women crossing the border. Those abortion clinics right now, we're looking at the statistic my sister quoted me a couple of weeks ago was 300 women on the waiting list in Mississippi. Illinois is overwhelmed. And so when we talk about caring about well-being for people who want to have, as Justice Kennedy did, some types of restrictions that were put, it's okay to have earlier term abortions, but we don't want people in their second trimester having abortions. You really are creating a situation of danger for women because actually as the pregnancy progresses, it's more dangerous. It's a procedure that's more dangerous. And so I think when I think about the future of criminalization and who we're talking about, we're not just talking about women being punished. I do worry about what we're going to start seeing happening to the medical providers. And I don't like to read about what happened to medical providers in the past, knowing that that's really going to happen. And it's a live conversation among families that have abortion providers. So I suspect we will see women criminalized. We will see women criminalized, as we just saw in Texas, where medical providers are going to be snitching. And it's a tragic breach of their duty when people come to get care and they alert the authorities, but that is happening. And we'll see that happening more very likely, creating a whole range of problems for people seeking reproductive health care when they're having miscarriages that are not self-induced. And so the downstream effects of, even if there isn't active criminalization like we saw in Texas, and again, I think there will be, we'll see those secondary effects of people being afraid to go get medical care. We're going to see harm possibly coming to providers, and others can probably speak to other effects of criminalization. One last effect as a socio-legal scholar is, again, people's liberty will be removed, but what we think and how we relate to our bodies and our autonomy is also going to be so deeply affected by this.
Hopefully this is better sound. Yes, no, better. Yay, good. My computer crashing was a service. Yay. So I want to name that, like, what Jamie's speaking to is already happening, right? The chill effect is already happening. It's not just happening with people who are seeking abortions, it's happening with the providers as well. As I listen to providers talk about, can we train people? What will happen if we train abortion providers, right? Like, where does the pipeline and building the bench, how far does this really reach out to and really start to dismantle the system in place for us to receive the healthcare that we deserve? Like, providers in this state don't know. Could they be held legally what's the word I'm looking for? Reliable. That's the word. Could they be legally liable for just doing basic medical education, right? So I think it's really important for us to think about and understand that these practices are already happening. And again, as we hold like a liberatory standpoint and not a judgmental standpoint, that as we think about self-managed abortion, some people are doing self-managed abortion through their communal practice, their community practices, right? They're not doing self-managed abortion through medication. And we don't want to get into any kind of way where we start to, again, have some kind of level of what is acceptable and what's not acceptable. It's about what is in the best interest of the person who would like to proceed with that procedure. They would like to have an abortion. What does that look like? What is the best way that they want to go about that? Is it based in their community practices? Is it based in a hospital? Is it based in their home? Right? Like, there's so many different ways that people can safely access this and access the different ways that we can go about getting our abortion. And it's really important that we think about that people are already feeling the impact of the chill effect. People are already feeling and working towards safe methods. So this is all like remembering that it's not something that's just going to shift on. It's already happening.
I also think that the question of whether abortion is legal or not is not the only question about what it's going to be like. In other words, so if we think of the 1850s to the 1870s as a period of criminalization, so what was the 20th century like? What were the 1920s like? Well, in the 1920s, abortion was pretty safe. There were lots of practitioners who did it often. It was pretty normalized in communities. Lots of people talked about it. They might not talk about it entirely openly, but certainly the conversation was there. People knew where to go. In the 1950s, however, the conversation was really different. People were terrified. Safe, reliable practitioners were criminalized, thrown in jail. And so abortion became much less safe. People talked about it less. People had more shame and more fear about it. And so what made the difference? Well, a lot of things, but among other things, we can make a difference by how we act in our communities, right? The more practitioners, for example, decide that it's too terrifying to do abortions in Texas or Mississippi, the fewer practitioners there will be. The more people speak out in support of practitioners, the safer it'll be.
I want to pose one last question to you all, given that we end in about 6 minutes. A number of questions that we had sent in are asking about, what are better legal arguments to ensure abortion? So in other words, what are alternatives to what many legal scholars on both the left in some cases and often on the right critique about Roe's focus on privacy? And related, is this a topic that should even be legislated by the state? And I know, Laura, this is a question that you grapple with in your work and many others of you do as well. So I'd love to hear your feedback on that question.
Well, I can speak a little quickly to that. With this court, I'm just not sure that the Supreme Court, I don't think that legal arguments are where we need to be putting our time and energy with the current court, with a 6-3 super conservative supermajority. But at the state level, I think that there are a lot of good arguments that can be made that we should be advocating. Although, in progressive states, we're winning those things. I mean, Illinois, Massachusetts, New Jersey now, California are passing very strong, excellent laws. By the way, I just wanted to note, Connecticut passed a provider protection law recently that I hope Massachusetts will do as well, to protect people if they help people in other states from any sort of attempt for those states to come in and enforce judgments against them in the Connecticut courts. I think we've got to be thinking along those lines. But I think that there are free speech rights. I think there are equality rights, strong equality arguments for abortion rights. I think that there are privacy. I think those are good arguments, even though they've been disregarded. I think that there are freedom of association arguments. So, Roe was so narrow and there was so much more that could have been done. The fact of the matter is, you take abortion away, sex equality, women do not experience equality in society. And but that argument never got a lot of play. It did in some of the later decisions, but was clearly rejected by Alito in the current opinion. But I think and it is being actually argued right now before the Pennsylvania Supreme Court under their ERA with regard to a Medicaid funding case. So I think that those equality arguments are being made at the state level.
Anyone else want to weigh in on that quickly? And Jamie, here we go.
I'll say one thing. I think we have to pay more attention to the question of whether the 13th Amendment abolishing enslavement also abolished forced pregnancy. It was part of the congressional debate about the 13th Amendment. And I think we've got to keep putting in front of people that we have a history of forced pregnancy in this country, and it's the history of enslavement, and that we don't have to accept that. And the argument about adoption is frankly horrible. right? It's saying that you can engage in an extremely risky thing. Like if you're African American and you live in Texas, that makes pregnancy one of the most dangerous jobs in the country. Okay. And so what we're doing is we're saying people who would typically pay $50,000 to $100,000 for somebody to carry a pregnancy for them as a surrogate now are going to pay nothing to force somebody to do one of the most dangerous jobs in the country, and they are going to get that baby. They are going to be able to. Now, it's not that I'm making an argument against adoption in general, although I think we need to have a lot more conversations about why birth mothers are not able to raise their children. But most people never choose between abortion and adoption. They choose between adoption and raising their child. And abortion is a different kind of decision. It says, I am not prepared to carry a pregnancy right now. It's not healthy for me. We know from the Turnaway study that people who seek an abortion and are denied one are twice as likely to die and much more likely to have long-term health consequences as a result of pregnancy. I think we have to keep insisting that those kinds of arguments can't be allowed to stand, that we have to be talking about people's bodily autonomy. And when we talk about people who can get pregnant being denied bodily autonomy, we are talking about a practice of enslavement that has a history in this country. And I don't say that in a glib way, right? African-American women are 2 to 3 times more likely to get abortions. This is not a race neutral issue, we've got to take that seriously.
I'm moved by that and almost want to, I don't want to break up that extremely important call. In the work that we do as legal scholars, and in my work, it's why do we turn to courts to solve entrenched social and political problems? And so my early work looked at war. Why do we think that international criminal courts are going to stop war? I feel similarly about this issue over time. If you look at how lawyers are trained to think, if you read what Alito just did with the standards and the application to a very narrow set of facts, it was every critical legal scholar's either dream or nightmare, depending on your perspective, of putting an ideology into cold legalese, I think, as someone wrote. And so I do think that there's going to be a reckoning. There already is, there has been over the last decade, about what it means to put faith in particular social change goals into the courts, when to be strategic about avoiding courts. Those are issues that all different social movements are addressing right now. And that's what I'm trying to bring up about strategizing around the political process, which is messier and involves a little bit more compromise. It's harder to be as hard line, because in a court case, you want to make you right and the other people wrong. And in the legislative process, there's more compromise and room. And that's not pleasant when we're talking about an issue that for people feels like life and death on both sides of the issue. And so I'm really interested in learning more about, models for how we think about moving forward when a right is taken away at the court level and moves back into local state politics.
I think that is a great comment on which to end. And I hope that we can have a follow-up on what those models might look like, and maybe even bring in someone who is enacting that model. I just want to close by thanking all of you for taking the time to be here. I feel like the conversation has only just gotten started, and to be sure, this is going to be an ongoing dialogue. And I just want to end by quoting actually a comment that someone wrote in about the panelists. They wrote, "What an incredible panel of strong feminists. The dedication of each of you gives me hope in the midst of despair." So thank you. We so appreciate your time. And for the audience members, you will be receiving a link so that you can look at all of the links that we've provided, as well as the transcript and recording of this panel. Thanks so much.